everybody, it's Harvard lawyer Lee, and today I'm going to be talking about a $150 million lawsuit between two of Hollywood's biggest names. Johnny Depp is suing Amber Heard in Fairfax County, Virginia, and boy, is it ever a doozy. I'm Harvard lawyer Lee, and today I'm going to be talking about the case that has just about everything thrown in. Abuse, lying, cheating, slandering, and even Elon Musk as a witness. It doesn't get any crazier or more interesting or more serious. I'm blogging this trial over the next week, and you have got to subscribe. You do not want to miss a day of this trial. Please also like and comment what video you'd like to see next, what facts you want me to talk about, address, and talk to you about. Now, yesterday, I talked about Johnny Depp's case against Amber Heard. She accused somebody, and pretty clearly it was Johnny Depp, of sexual violence against her in an op-ed piece in the Washington Post. So Depp sued Heard for $50 million for defamation. But Amber Heard countersued Johnny Depp. And today I want to talk about what Amber Heard's suit against Johnny Depp is about. It was for $100 million, also for defamation. Now, Amber Heard had 3 counts in her complaint. In her counterclaim. And the judge has already ruled on some of those claims. Did she win or did she lose? Keep listening to find out what the judge ruled on Amber Heard's counterclaims. Now, Johnny Depp and Amber Heard, if you don't know already, were a made-for-Hollywood perfect couple. She's an actress, he's an actor, but their 2-year marriage was bitter. It was marred by problems that have not yet ended, even years after their marriage ended in 2017. The first count Amber Heard brought was for a declaratory judgment. What she said in that count was what she wrote in the op-ed piece was protected under the First Amendment, so she was immune from suit. Now, did she win or lose? I'll give you a minute to think about it. Do you think she won, lost? Lost. The court dismissed this. The court said this count is really just duplicative. It's just a way of saying I should win the case brought against me. It's not really a true counterclaim. She'll get to make all the arguments. She just won't get to make them in a separate format. So count 2, defamation and defamation per se. Now, those are the exact same things that Johnny Depp sued for, but obviously very different statements. There were 8 different statements she mentioned, only one of which Johnny Depp actually said himself, and that's important. I'll talk about that in a minute. The first was a November 2018 interview with GQ. Depp said there was no truth to what she was saying whatsoever, that she fabricated the bruising that she claimed he gave her when he beat her, and he said to harm someone you love is some kind of bully. No, it didn't. It couldn't even sound like me. Now, this was the only one that he said himself. The rest, she says he said through his attorney. In other words, he had his attorney say them. He didn't say them himself to the newspaper. The attorney made the statement to the newspaper. So what do you think the court ruled on this? What do you think? No, barred by the statute of limitations. Now, the statute of limitations doesn't address the merits. It doesn't mean that Amber Heard was wrong, that Johnny Depp never said those things. All it means is she waited too late under the law to bring the claim. She only has a limited amount of time to bring claims under the law, and that interview was too old to count in the lawsuit. That was why it was dismissed. Second statement, April 12, 2019, to page 6. Depp's attorney accused her of committing defamation, perjury, and filing and receiving a fraudulent temporary restraining order demand with the court. Now, this related to her request for a restraining order against Depp because she said he hit her. What do you think? Up, down, down. Court barred it. Statute of limitations again. Third statement, June 2019. Through his attorney, Depp told the Blast that Heard continues to defraud her abused hoax victim, Mr. Depp, and masquerades as the leader of the Me Too movement. No, barred by the statute of limitations. Number 4, July 2nd, 2019, Depp, again through his attorney, told the Blast that Heard went to court with painted-on bruises to obtain a temporary restraining order. Barred. Statute of limitations again. Fifth, July 3rd, 2019, the attorney told People magazine that Amber Heard's battered face was a hoax. Barred by the statute of limitations. All of those were the ones, included the one by Depp and the 4 by the attorney, and all of those, he ruled, were barred by the statute of limitations. But there were 3, spoiler alert, the next 3 were all late enough to pass the statute of limitations and to be left in the case. And here's what the 3 remaining defamation statements are that she's relying on. On April 8th, 2020, Depp's attorney told the Daily Mail that Heard and her friends in the media used fake sexual violence allegations as both a sword and a shield, depending on their needs. On April 27th, 2020, Depp told the Daily Mail, Depp, or through his attorney, told the Daily Mail that this was an ambush, a hoax, that they set Depp up by calling the cops, but they left, the cops, left because they saw no damage, either to Amber Heard or to the property where the couple lived. So Amber and her friends, they said, spilled a little wine, roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed a second call to 911. That statement's still in the case for defamation. Third statement that's still in the case, June 24, 2020, said to the Daily Mail, accused Amber Heard of committing abuse hoax against Depp. So does that mean that Amber Heard won on those 3 statements, that she proved that Johnny Depp actually defamed her? No, it doesn't mean that. Not at all. This was simply a motion on demurrer. Depp said, here's sort of what that means. Depp said, well, there's no evidence about this. So little, why would we even have a trial about that? And all the judge said in his ruling was, I'm going to let there be a trial. I am going to let the jury decide. I'm not going to make the decision right here at the very beginning of the case. So at trial, what will Amber Heard have to prove? Well, to prove defamation, she has to prove 3 different elements. The first is publication. What was said has to have been published to be defamation under the law. For example, there's a text exchange that has been quoted where Depp wrote to his Avengers co-star Paul Bettany, and he wrote, and it's pretty violent language really, but he said, let's burn Amber. Let's drown her before we burn her. I will blank her burnt corpse afterwards to make sure she's dead. While completely offensive and improper, that text exchange is not defamation because Depp didn't publish it. He didn't talk to anybody about it. It was simply a text message to one person. So shocking language, but not defamation. Will it come into trial, though, into evidence at trial? It might, because one of the elements that we're going to get to is intent. And that might be relevant on the issue of intent. We'll see what the judge rules. So the second element of defamation is it has to be a publication of an actionable statement, meaning it has to be both false and defamatory. So false, obviously, means it's not true, but defamatory, here's what that means. It means tends to injure one's reputation in the common estimation of mankind. Read it again. Tends to injure one's reputation in the common estimation of mankind. Now, I'm going to give you Harvard lawyer Lee's explanation of what defamatory means. It's where you said something, even your mama is going to think a little less of you after she hears that. It's that kind of statement, you know. She heard that this was said about you and that you did this, and she said, everybody's going to think less of you. That's what defamation is, that when somebody says that about you. Now, the third thing is with the requisite intent. Now, of interest, Amber Heard, in her statements against Johnny Depp, did not actually state his name in that article that she wrote, that op-ed piece. She gave enough indicators that it was pretty clear who it was. She said it was 2 years ago. She said it was abuse, which had been very public at the time. There are arguments over that, their court case over that. So it was pretty clear who it was. So Depp is going to say all he was doing was defending himself with the truth. Now, Amber Heard is going to argue that what he said was said with malice, that he made these claims. For example, that the GQ journalist, who was Mr. Heath, said that Depp wanted to give an interview because he was angry about a lot of things, and he's vengeful. That Depp told friends he intended to ruin her career, and that Depp said he wanted Amber Heard replaced on Aquaman. So the fourth issue that will come into play is that Amber Heard alleged not just defamation, but that what was said was defamatory per se, meaning it was an accusation that would amount to a crime if you had done it and it was untrue. So, for example, if in fact he lied when he said or his attorney when they said she staged a crime scene and lied to the police, well, if that's false, yes, that would be defamation per se, because it's a crime to stage a crime scene. It's a crime to lie to the police. So here is an extra layer for her case, though. Remember, it wasn't Johnny Depp who said these things. It was Johnny Depp's lawyer. But Amber Heard didn't sue the lawyer. She only sued Johnny Depp. I'll be honest, I'm a little surprised by that. I'll tell you kind of the thinking that a lawyer would go through in making that choice. The reasons to include the lawyer are the lawyer is the clear actor here. If you can prove it's defamation, well, you win your case against him. If you sue Depp, you have to prove that Depp authorized those statements, that the person was speaking on his behalf. So almost always, you would tend to include the lawyer in the case. There are some reasons not to that must have been more powerful in Amber Heard's lawyers' minds when they made the decision. One example would be if you're afraid that the jury is going to blame the lawyer and let Depp off the hook. The lawyer is not going to have anywhere near the money that Depp does to pay, and therefore you might want to focus the case on him. It would also create a lot less of a public splash if what you do is sue a lawyer who said this on behalf of somebody as opposed to Johnny Depp himself. It's also possible it was very difficult for some reason to get service. Could have been difficult to get venue over the attorney in Virginia. I don't know enough of the facts about that decision that they made to know why exactly they made that choice. But regardless, their choice was to sue Depp and not to sue the lawyer. So they'll have to prove that extra layer that the lawyer spoke on behalf of Depp. And I don't know. The evidence on that may be abundantly clear. It may be completely clear that Depp said, please go do these interviews on my behalf. I don't know. We'll find out at trial what the facts are. So, and then her third claim really was probably the most interesting claim of all. She alleged that Depp and his attorney, or Depp through his attorney, violated the Virginia Computer Crimes Act. What she was talking about was an allegation that she and her counsel had made that Johnny Depp coordinated Change.org petitions against her to take her off Aquaman and to take her off as spokesperson for L'Oreal. Also, that they created social media accounts, the sole purpose of which was to target her. Now, did the court let her bring this case? No, the court dismissed this case. Here's what the court said. The court said the Virginia Computer Crimes Act is pretty specific about what it targets. And just because you create petitions or create social media accounts does not involve necessarily the things that the Virginia Computer Crimes Act addresses. It doesn't involve obscene language. It doesn't threaten illegal or immoral acts. It doesn't suggest or propose obscene acts. So the court said, I don't think this fits. It doesn't fit within the statute. And so didn't allow those claims to proceed. Those are particularly interesting because this is kind of a new area in the law. I mean, the very concept of somebody being able to agitate and create online petitions, really fascinating, interesting material that's going to be in more and more cases as we proceed with social media. Now, thank you so much for watching the video. Don't forget to tell me in the comments about who you think is right, and I'd really like to hear what topics you want me to cover next. And subscribe, please subscribe, because you don't want to miss the updates about this next trial.